Hi friends, this is 6th class of IPC and this is Lokesh Pathak with you, and today we are going to discuss general exceptions, which is chapter 4 of Indian Penal Code. So here for the general exceptions, before we go to the details and the categories of general exceptions, first of all we should know what exception is and how it is being seen in the case laws in Indian jurisdiction. So first of all we would see the very famous case which all of you might be aware is KM Nanavati versus the state of Maharashtra. It is AIR 1962 case, and that case is one of the renowned cases of Indian jurisdiction. So in that case it was held that the burden of proof in general exception is on the accused. So general exceptions are basically the defenses which a party take to protect him from any criminal conviction or offense. So these general exceptions, the burden of proof, as I said, it on the party which is accused. So there is a jurist Huda. He says that conditions of non-imputability are general exceptions, while there is another jurist, Kenny. He described that the conditions of exemption from criminal liability is called general exceptions. So it's quite clear to remember Kenny's interpretation that general exception is exemption from criminal liability. So you can relate the two, exception and exemption. So it will be easier to learn and remember it. Now general exceptions are split into 7 major categories in the Indian Penal Code. The first is mistake of fact, which is described in section 76 and 79. Second is judicial acts, which is described in section 77 and 78 of IPC. Accident, which is section 80. Absence of criminal intent, which is divided into parts. The first part is section 81 to 86, and the next is section 92 to 94 of IPC. Then consent, which is section 87 to 90 of IPC. Sixth is trifling act, which is section 95. And seventh and the last is private defense to the person or property, which is section 96 to 106. So as the name might have suggested you that all these categories are exemptions. You can bear those exemptions, you can prove them, and then you will not be convicted in the offense. But the procedure and the details of these to be known is very important in order to obtain the exceptions. So the mistake of fact, judicial act, accident, absence of criminal intent, consent, trifling acts, and private defense. So we'll see all them one by one, that what it is. So the first is mistake of fact. As we discussed, it is in section 76 and 79. So 76 says very clearly that nothing is an offense which is done by a person who by a mistake of fact, but not by mistake of law, in good faith believes himself to be bound by law to do it. It means a person, if he does something which is because of mistake of fact, but not the mistake of law, means it is assumed or it is anticipated that each and every person in the society, he should not commit any mistake of law. He should be aware about the law. And while the mistake of fact, if he is under a mistake of fact and he does something, but the important is good faith here. In a good faith and the belief that what he is doing, he is bound by law to do it, he is correct, and he does so by a mistake of fact, that is not an offense. Example is, if A is an officer and he is being ordered to arrest Y, after inquiry, believing some other person Z to be by Y and arrest Z. So then in that case, A arrested a wrong person by mistake, but it's by a mistake of fact. So he has committed no offense. No offense can be made against him. Now the concept of mistake, which we discussed, it's an important thing to know, because what I said is that the mistake of fact is excusable, but not the mistake of law. From where this came? Before we go further in other sections of exemptions, we should know what mistake is, because it's important to be determined. So the source of the fact that mistake of fact is excusable but not the mistake of law is a doctrine of mens rea. There is a Latin maxim on criminal law which states that ignorantia facti excusat, ignorantia legis neminem excusat. I repeat, ignorantia facti excusat, ignorantia legis neminem excusat, which means in English that the ignorance of fact is an excuse, but ignorance of law is no excuse. So this maxim of criminal law is very important, and it is being used in all the spheres, like somewhere in contract law also, in the Indian Contract Act section 20, 21 and 22, the reference is seen that the mistake of fact, which was in section 20 of Contract Act, it is allowable. The contract under that category is made void, but not the mistake of law. as seen in section 21 of the same act. So the same way in criminology, if we come to IPC, the same holds good, and the principal maxim is just being discussed. So this is all about the maxim and the concept of mistake. However, in IPC, this maxim is not blindly followed. It is said that there are two exceptions to this maxim itself, and those exception is: first, the ignorance of fact not allowed if responsible inquiry can elicit the true facts. So you cannot take the result of ignorance of fact if you could have performed a genuine inquiry and you could have found out the facts. So if there is a chance or there is a probability that the person who is who's seeking a result in exemption as per the mistake of fact, if he could have inquired and got to know the real fact and would have avoided the offense, then that will be an exemption to this. And other exemption is in the cases when the act is penalized by a statute without reference to the mind of the wrongdoer. If there is no reference or weightage to a mens rea in a particular act and the person is being penalized, then also there is an exception to this maxim. Now, mistake of fact, as it is very clear that if it is a mistake of fact, then the person will be held liable. Now, the mistake of law. Mistake of law is not excused in the IPC as well as in other sections of law. It is based on a maxim that ignorantia coram qui quis scire tentior, non excusat. I repeat, ignorantia coram qui quis scire tenitur, non excusat, which means ignorance of those things which one is bound to know excuses not. So ignorance of law is not excused in law, as I said. It includes two components. Like mistake of law is having two parts: the mistake as to existence of any law on a particular subject, as well as second is mistake as to what law is. So you should know that there is a law, and you should also know that what that law is. So these two are important in consideration to mistake of fact. So this is the first point, first exemption we discussed, that the mistake of fact, which is mentioned in section 76 and 79, and we are aware based on this that the mistake of fact is excusable while mistake of law is not. Now let's see what section 76 and 79 says in particular. 76 we have just seen that the person who does the things in a good faith under a mistake of fact has committed no offense, while 79 says that act done by a person justified or by mistake of fact believing himself justified by law is no offense. So here the important factor is justification. Okay, now the second exemption in IPC is judicial act, which is mentioned in section 77 and 78. Section 77 says that judicial act by judge in exercising his power is no offense. So if a judge delivers a verdict and in that he penalizes somebody or he does decide over something, so that cannot be constituted as an offense. Similarly, in section 78, any act done pursuant to any court judgment is also no offense. So with both these two, we can say that the judicial acts like decision by a judge and the act of a court in pursuance of any court judgment or decision, these both are no offenses. Now the third exception is accident, which is section 80. In section 80, the accident is very duly defined with its components. So we should see what it is and how it is interpreted. Section 80 says that nothing is an offense which is done by accident or misfortune and without any criminal intention, in doing a lawful act in lawful manner and by lawful means, and without proper care and caution, and with proper care and caution. So here the situation can be classified into four parts. You should remember that nothing is an offense, first, which is by accident or misfortune; second, without any criminal intention; third, in doing a lawful act in lawful manner by lawful means; and fourth, with proper care and caution. So if you satisfy and mention these four conditions, then the person cannot be held liable for an offense. Okay, so now in the case of accident, what is the situation of burden of proof? Here we would like to refer again the KM Nanavati case, KM Nanavati versus State of Maharashtra, AI 1962, where it was held that burden lies upon accused to prove that his case falls as an exception in case of accident. Now another case which is related to wrestling in accident due to wrestling is Tunda versus State, which is AIR 1950 case. In that case, it was held that an accident resulting in death, but the act was with the consent of both the parties, and there was no foul play involved on the part of accused, then it is not an offense. So any agreement or consent to fight a wrestling, and if somebody expires or dies, and but the consent was taken and there was no foul play involved, so that is not an offense. That was held in the case of Tunda versus State, AIR 1950. Now the fourth exception is absence of criminal intent. Here the factor is the mens rea. So if mens rea is not there, there is no offense. So it has been taken up in IPC in two parts. One is section 81 to 86 and the other is section 92 to 94. Section 81 says that an act likely to cause harm but which is done without criminal intent and to protect other harm is no offense. It means that if a person commits an offense with a minor harm but he did so with an intention but without a criminal intention, and the purpose of doing that act is to prevent a very big harm, is no offense, but that need to be justified in the court of law. Section 82, it says nothing is an offense which is done by a child under 7 years of age. So it's a minor. So if a minor less than 7 years of age, if it does an offense, it's no offense. Now section 83, it says the child under 7 to 12 years of age, but if he has not attained the sufficient maturity to judge the nature and consequences of his conduct or act, then that act will not be considered as an offense. So, but the important thing is here is that the incapacity to perform the crime that should exist at the time of incident. Now section 84, it talks about an unsound person. That act of a person of unsound mind is no offense. So, but it needs to be established by credible evidences. So, the need of this credible evidences to sustain that the person is of unsound mind, it was elaborated in the case of Ilavarsan versus State, AIR 2011 of Indian jurisdiction. So, in that case, it was held that the person who is of unsound mind, there must be a credible evidence which is acceptable to court of law, and as per that only that person can be declared that of unsound mind. So now before we go further, this unsound mind in criminology, I would like to discuss a bit on this. A person of unsound mind in IPC, it's called non-compos mentis. So this non-compos mentis is generally of four types. The first is an idiot, which is a naturally insane person, and since birth he is an idiot, and maybe he can have lucid intervals, but the court justifies an idiot or identifies an idiot by certain acts. Those are, if a person who cannot count up to 20, or if he cannot tell the days of a week, the name of the days of a week, it is declared as a born idiot or naturally insane person. The second category of unsound mind is lunatic or madman. These both are acquired insanities. Lunatic is a person who is afflicted by mental disorder only at certain periods, while madness is a permanent instability of mind, unsoundness of mind. So these are the acquired insanities. The third category is non-composed by illness. If a person is under the influence of a mental disorder, and by illness if he is of unsound mind, then he comes in the category of non-composed by illness. And the last one is one who is drunk. But the drunkenness should be, or intoxication should be, not self. It should be without his knowledge or against his will. So these four are the types of the unsound mind persons. So that needs to be taken into account. So now the next is section 85. So now we have known that what are the unsound person and what is the intoxication. So section 85 says that act of a person who is incapable of judgment by reason of intoxication caused against his will is no offense. So if somebody is intoxicated against his will and against his knowledge, then the act committed by him is no offense. Okay. Now, but there was a case which is Mirza Ghani Beg versus the state of Andhra Pradesh. In that case, it was seen that the drunkenness was there, but it was a voluntary drunkenness. Person was aware, he knowingly drunk and committed the crime. So here he cannot be held exempted and he was liable of crime. Section 86 says that where offense is not possible without particular knowledge and intent, intoxication loses its relevance. The same case it was held, like in the case of Mirza Ghani Beg versus the state of Andhra Pradesh, it was held that the person who committed the offense, if it is not possible to commit that offense without the particular knowledge and intention, then intoxication has no relevance in that case, and the person will be taken up as a offender. Now the second set of absence of criminal intent, which is mentioned from section 92 to 94. 92 says that act done in good faith for benefit of a person without his consent is no offense, provided there are circumstances so as to consent cannot be taken from that person and nor from his legal guardian. If they are not available for consent and the person cannot give a consent, and the person who's doing an act, he's doing that in a good faith and for the benefit of such person who cannot give his consent, so any act without his consent also will not be considered as offense. Section 93 says that any communication made in good faith is no offense. Section 94 says that act to which a person is compelled by threat is no offense, provided the situation caused him to get an apprehension that if he does not perform that act, he will be subject to the instant death or any other consequences. But it doesn't mean that the person who is under a threat, he can murder a person, because in this clause, in this section of IPC, there are further exceptions. This section is not applicable to murder and offenses against the state punishable with death. So except murders, if somebody is under a threat that and he is under that threat that if he does the act which is he is asked to do so, he will be subject to the immediate murder or death. So that will not be an offense. So these are the conditions for the absence of criminal intent. Now the next category, fifth category, is consent, which is mentioned in section 87 to 90. Section 81 says, for a person above 18 years of age, any act which hurts, but the exemption here is it should not be a grievous hurt or death. So if a person is getting hurt and he is above 18 years of age and the act is done by his consent, it will not be an offense. So it means if you give a hurt but not the grievous hurt or death, if you give a hurt to a person who is above 18 years, he gave his consent, so you will not be subject to any offense. So this is for the all risk sports and all. There is a consent and the person is above 18 years. If he gives that consent for hurt, then it is acceptable. But it doesn't mean that the person is allowed euthanasia. It means that if the person gives the consent for his death, and if he goes so, or the person helps him or attempts at the death on him and he dies, so that in that case it will not be considered as an exemption. So here we remember a maxim which we learnt in taught, that volenti non fit injuria. The same is applicable in IPC, that he who consents suffers no injury. So injury is not admissible if the person has the consent, he is a major, if he consents, and the nature of the injury is hurt only, not grievous hurt and not death. Section 88 says that act which is not intended to cause death, done by consent in good faith for person's benefit, is not offense. So 88 determines again the importance of consent, that act which is not intended to cause death, any act apart from death which is done with the consent of a person in a good faith for the benefit of that person, will not be considered as offense. So here all the medical treatments, consent forms and all that comes in this category. Section 89 says act done in good faith for benefit of a child or insane person by or by consent of his guardian is no offense. So it just extrapolates the section 88 to the case of a child or an insane person or a minor, and here it determines the importance of the consent of his guardian. Section 90, which is very important, it says that consent knowing to be given under fear or misconception is no consent. So here we can relate it with the Contracts Act, the Indian Contract Act 1872. There in section 14 to 20, it says all the conditions which are against the free consent. If any of those conditions like fraud, misrepresentation, mistake, coercion, undue influence, if those got included, then the validity or validity of the contract is challenged. Same way here in section 90 of IPC, in the exception it says that the consent should be free. If it is under fear or any misconception, then it is no consent. Section 95, which is the sixth exception, it talks about Trifling Act. So what is a Trifling Act? Trifling act as defined in section 95 is any act which causes a slight harm is no offense. The term here is a slight harm. Now, how this slight harm is controlled? So it says, provided that no person of ordinary sense and temper would complain of such harm. So, what is a slight harm? If a ordinary or a normal person, he cannot feel the importance of complaining for that harm, is a slight harm or trifling act. So such trifling act or slight harm, say somebody touches you by his elbow and you have no harm, but it's done by chance. You cannot go in the court of law for claiming that it is a crime or offense or it is against your dignity. So this all are coming under the category of trifling act, which is section 95, and these are also no offenses. Now the most important in this category, the seventh one and the last one, is right of private defense, which is very important, and you can definitely find a question related to this in your exams, in any of the exams or interviews. So it is defined from section 96 to 106 of IPC. And what is the right of private defense? Section 96 says nothing is an offense which is done in the exercise of the right of private defense. So if somebody does something for his defense and to protect him, so that act will not be considered as an offense. So there is a case which is Madan Mohan Pandey versus the state of Uttar Pradesh, 1991 SC. In that it is held that in judging whether accused has exceeded its right of private defense, court has to take into account the weapons used. So here this case is very important, because right of defense does not mean that you can exceed the power. If somebody pokes a finger in you, you cannot just take a revolver and shoot him. That is exceed of power. Your reaction should be in proportion to the act, what the person has done. It should neither be instigation, it should not be retaliation either. The retaliation means if the person, he has done something, you gone away and after 5 minutes you give it a thought and then you came and you tried to attack that person and you say, I did in private defense. No, it's not admissible. It should not be a retaliation. You should not be in your minds to do so. You should be in a position of immediate defense. Then you can take a resort of private defense. There's another case which is Rizan versus the state of Chhattisgarh. It's AIR 2003, and that it was held that to be proved by accused that the harm caused by him was necessary to ward off the attack. It means that the accused, he has to prove that if he would not have done the reaction, he would have been dead or grievously hurted, or any other thing grievous was supposed to be done with him. Then only he can take a resort of private defense. Another case is Pammi versus the state of Madhya Pradesh, AIR 1998. In that case, it was held that no right of private defense can be claimed against an act of self-defense. So if somebody is doing a self-defense, the counteract cannot be taken as a resort of private defense. So it should be a plain act against which you can seek the resort of private defense. Section 97 says, right of private defense of body and property. Every person has a right subject to the restriction which are given in section 99. What section 99 is? We should read it first. 99 is no right of private defense against an act being done or attempted to be done by a public servant. So you cannot take the resort of private defense against a public servant. This is section 99. So now section 97 takes a restriction. It is subject to restriction made in section 99, means any private defense is not against a public servant when he is exercising his legal duties or legal powers. So section 97 says that right of private defense, every person has a right subject to restriction of section 99 to defend two things. First thing is own property plus his own body plus body of others against offenses against human body. And the second is his or others' property, which is movable or immovable both, against an offense which is falling under theft, mischief, robbery, or criminal trespass. So section 97 says that the person can use the right to private defense against his body, others' body, his property, or others' property which is movable and immovable. Section 99, as we said, we have just seen that it is a right of private defense is not available against a public servant who is exercising his powers. Section 100 says The right to private defense of the body can extend to causing death, that the person is allowed to make the death of the attacker, but there are certain conditions, and there are 7 conditions determined. These are: first, assault apprehending the death as a consequence. Means if the person is under an impression that this assault is going to make him die, he can use the private defense, and that private defense can be extended up to the causing the death of the attacker. Second is assault apprehending grievous hurt as a consequence. Third is assault with intention of committing rape. Fourth is assault with intention of gratifying natural lust. Fifth is assault with intention of kidnapping or abduction. Sixth is the assault with intention of wrongfully confining a person. And seventh and the last is an act of throwing or administering acid or attempting to do so. So in all these categories, the person who's under this impression or apprehension that he can be subject to all these things with the attack of some other person, he can use the private defense, and if in doing so he commits the death of the attacker, then he will be in court of law, he can be proved having committed no offense. Then section 102 says that right of private defense, it commences, the commencement and continuation of it, that the right of private defense, it commences when the person is having a reasonable apprehension of danger to body, then it starts, and it continues as long as the apprehension continues. Now the another section and the last section which is important in private defense is section 103, which says, now we have seen that the right of private defense, in section 100 we have seen that the right of private defense, it can extend to causing death under certain circumstances which are related to attacks with the body. Now section 103 talks about it in terms of property. It says that the right of private defense of property extends to causing death under 4 circumstances, and these are: first is robbery. Means if the person is committing a robbery, then the person in his private defense for his property, he can use the private defense, and if he causes death of the person who is doing a robbery or attempting to do it, then it will not be an offense. Second exemption is housebreaking by night. Third is mischief of fire in a building, and the category for that building is should be a human dwelling or custody or property. Fourth and the last is the theft, mischief or house trespass to give apprehension that death or grievous hurt will happen. So the person who's experiencing a theft, mischief or house trespass by the offender, and he is under the impression that if he does not act, he will be subject to death or any other grievous hurt, then he can protect himself, his property, and in doing so, if he causes the death of the attacker, he will not be held liable or liable of any offense. So this is all about the private defense, which was the 7th category. With that, I would like to wind up this lecture. So this was a big topic. It was having general exceptions. There were 7 categories we discussed with the appropriate case law and with the positively a convincing justification I tried to give. So just take it as a reference, and before reading book, if you go to my lecture and you listen that, you will be having an exposure of the total content of what you are going to read, and that will be helpful to you. That is my intention. So stay tuned with me and subscribe to my channel, and see you in other classes of IPC. Bye bye. Have a nice day.